software that embraces and celebrates entrepreneurship and innovation. So this year's is going to be, we usually have in June, this year's is going to be a little later. We're trying to coordinate it with the academic schedule so we can get more students involved in our fast pitch competition. So we'll probably be moving it into the August-September timeframe. You ready?
You good?
Okay. You're up.
Welcome everyone. My name is Eric Waltmire. I'm a patent attorney. My office is based in Wheaton. My background's in computer science, so I handle electronics, computer science-based patent applications. Also, my father was an auto mechanic, and I probably rebuild every part of the vehicle. So I have a fair amount of practical experience with mechanical, and through the course of my work, I've done subject matter ranging from chemical to vehicle related subject matter and clean energy and solar subject matter as well. I also work, I handle patent and patent, trademark, and copyright work as well. So I help businesses choose product names, select names that can achieve strong protection, and further, occasionally I do some copyright work as well. So.
Good. Welcome as well. My name is Matt Mondek. I'm a degreed engineer in mechanical engineering. I like to say I'm a recovering engineer because that never goes away. In the process, I picked up a master's in business, a professional engineering license, state of Illinois, and I'm also a certified purchasing manager. I've had a great career. I've had roughly 40 years of experience in both technical and leadership roles in the marine industry business, as well as the power transmission business. My most recent day jobs, as they call them, were as presidents and CEOs of companies. The first one was a private equity group, which we designed and manufactured custom industrial gearboxes. Not like what goes in your car, but these are 400 horsepower to 3,000 horsepower, 80,000 RPM output, some of them. The second company was an open gearing company, servicing a lot of industries, aerospace, medical, and so on and so forth. But like I said, I've had a great career because I've been able to span a lot of disciplines. And when I semi-retired 3 years ago, I founded Mondek Solutions, which is taking that 40 years of experience and helping other companies do what they need to do or can't do. And between myself and my colleagues that I've grown up with in my career, we can offer a lot of valued services to folks that normally may not be able to have access to that. So, my typical clientele is a small or mid-sized companies, and my sweet spot's engineering and manufacturing. If you have any questions, holler.
Welcome. Excuse me. My name's Jeff Dixon. I'm here from Hinshaw and Culbertson. I am also a patent attorney like Eric. My technical background's in mechanical engineering. I have a degree from the University of Nebraska, and I went straight from there to law school and became a patent attorney. And I've helped to file and procure patents in a number of fields, including more mechanically focused things like orthotic joints and vehicle wheel bearings and things like that, from also ranging into more software and IT related things, and a little bit of chemical stuff, but not as much there. And some electromechanical devices. And I've also done some work in trademark procurement and trademark litigation, and a little bit of patent litigation, and a very small amount of copyright. And that's pretty much my my focus.
Thank you.
Hi, I'm Yolanda King. I'm a full-time associate professor at NIU College of Law. I teach property to first-year students, and I also teach intellectual property, entertainment law, international intellectual property, trademark, and copyright, all during various semesters in my 6 years there. Prior to joining NIU, I was in full-time practice in Chicago for 7 years at 2 different law firms, and I practiced primarily in the areas of trademark and copyright. And I also worked for the City of Chicago's Department of Law for 2 years, and I negotiated contracts most of the contracts concerned IP or technology issues on behalf of the city. I do still continue to practice a bit from time to time. I'm of counsel at a small IP boutique firm at Beadham IP in Chicago, and I exclusively handle trademark and copyright matters there.
Okay, so we've heard a lot of intellectual property. We've heard a lot of facets or areas of expertise. We've heard patents, we've heard copyright, we've heard trademark. I'm going to ask each of you to sort of give me your perspective on when each applies. So maybe people in this room primarily are inventors, have products, or have concepts, some digital products, some physical products. So let's start with patents. When do I consider a patent, and what's the process to go through to decide whether I need a patent, and how much am I going to have to spend to get my patent? Who wants to take that one?
So I could field that one to start. Patents cover basically 4 types of subject matter, and my mnemonic for it is the 4 M's. It could be a machine, a manufacturer, a method, or a composition of matter. And basically this thing that you've invented, it has to be useful. It's got to do something that gives you some kind of an advantage, or cheaper, faster, lighter, more efficient. And new, which is sort of obvious. It's got to be, can't already exist, and it has to be non-obvious, which basically is a test that somebody of ordinary skill with the knowledge of who's aware of everything that's publicly available knowledge, it wouldn't be obvious to this fictitious person to come up with your invention, given their ordinary skill level and knowledge of what's out there, what's public. So when should you contact a patent attorney? You should, consider when you've got some kind of a new idea and it has some value for you. And you have an inkling that it's new. It's never really too soon to contact a patent attorney. You should get in touch with a patent attorney before you especially disclose something publicly, because you can lose rights when you do that, particularly with respect to filing any foreign patent applications. As soon as you disclose something publicly, most foreign jurisdictions have an absolute novelty requirement. You don't get any kind of a grace period. In the U.S., you still have like a 12-month grace period if you disclose something publicly. And so you basically, you can start by, one of the questions that was presented to me is can you do certain preliminary activities like searching and drafting up a description yourself? And the answer is absolutely yes, you should do that kind of thing, especially if you're not, if you don't have if you're not certain that what you come out with is entirely new, or even if you think you are, you can search the U.S. Patent Office database, and you can do an online search, and with your knowledge of the invention, what it is, you'll come up with a pretty good sense of what is the closest thing to it that's out there. And you may already know what that is just from your experience in your industry, but it helps to do a little searching, and then when you come to a patent attorney, you can give them what you think is the closest prior art, and they'll do a little supplemental searching on top of that to using those as sort of jumping off points, the references you provide to them, and then they can give you an idea of number one, can you get something patented over this stuff that's already out there, And number two, how broad that range of protection is gonna be available to you. And you can kind of decide based on that, whether it's prospectively gonna be worth the investment in a patent application.
Anybody else have something to add to that?
We could pass it over, sort of pass it to Eric and some.
Okay.
Jeff covered it pretty well. I mean, as he mentioned, one important point is there's an encouragement within the law to file your patent application early before you publicly disclose. Well, the law provides a grace period of 1 year, like was mentioned, but the boundaries of that are a little bit uncertain. And so this, whenever you're starting out with a product or a company, you have to balance. You have to decide whether you're willing to bear risk or whether you want the safest approach. Safest approach: go to an attorney, have them do a search, have them file an application before you do anything public, right? But a lot of clients say to me, "Hey, I don't even know if this is going to be a good product, and now I got to spend all this money with a patent attorney before I know it's going to go anywhere. What's the other solution?" And the solution is you start to bear risk, and you bear risk, like Jeff said, within that 1 year period. You could do some public activities, but there is risk with that. Someone else could run to the patent office ahead of you, and whenever you're second in line at the patent office, you have to spend lots more money trying to fight your way to the beginning than you would be as if you just filed early. So, the bottom line is, the safest. Sometimes you can't go with the safest approach. Sometimes you have to bear risk. And so, I completely agree with Jeff. The first step is do a search, right? You should probably do some searching yourself, or you can hire a patent searcher to do one for you.
What would the cost of a patent search? Just the search portion.
Well, it depends on the provider, right? It's going to vary according to whoever you ask to do that. There are places online that you can get to order for a couple $100s. If you go to a patent attorney and hire them, you're going to probably be into the thousands of dollars. And so, I think, as Jeff mentioned, it's a great idea for you to go to the patent office, go to Google Patents, find those resources online when you could do some searching yourself. Because just because you don't see it on the market doesn't mean that there isn't somebody else who has filed or a patent application or received a patent. It just, for whatever reason, didn't make it commercially. So you have to evaluate who it is you want to work with and decide what expenses you want to bear in that process.
What about a provisional?
So what I'd say about a provisional is there are, again, this is the cost versus risk. So the thing about a provisional is the government doesn't care what you file, right? You can take a back of the napkin sketch, put the right cover sheet on it, file it, the government's going to give you patent pending. The key, though, is the provisional is only as good as the content that's written in there, right? So, how I do it is I write a provisional just like I would write a non-provisional, because that's the only way I know that it's going to meet the client's expectations. Now, sometimes, again, somebody doesn't want to invest all of that. So they might decide to take their own write-up of the invention and file it as a provisional. So it's this balance. Do I have an attorney do it, or do I bear some risk, kind of take the do-it-yourself approach and file it yourself, or take a shot at writing it yourself after you've considered some resources on the topic?
Right. And if you're going to file the provisional application yourself, or if you're going to sort of cap it somewhere where your patent attorney can't put the same kind of TLC into the application that they would normally put into a non-provisional, there's going to be a more limited disclosure. And so yes, you have this placeholder that lasts for 12 months, and then you can file a non-provisional claiming priority to it. You get the effect of that filing date only for what that provisional discloses. So you don't want to just sit on that 12 months if you know, to the extent that whatever you've described in the provisional isn't complete, still the sooner you file the non-provisional, the better, because you're only going to have the full benefit of everything the non-provisional discloses as of that date you file the non-provisional, if you add anything.
What is the cost to file a provisional independently by yourself versus what is it cost to retain an attorney to do the patent application?
Provisional filing fees are a little bit less than the filing fees for non-provisional. It's in the low hundreds. I don't know offhand.
I
It's,
think, depends on
It
how much,
depends
what
on
your,
the
depends on your income. I think it's between 60 and 120, or could go up to 200 some, depending on the
Right.
size of your company.
Right.
So we're talking a couple hundred or less. Yeah.
right,
That's if you file it on your own, right?
right.
That's just the government fees.
Yeah.
When, I don't want to interrupt the conversation on patents, but whenever the conversation gets to copyright, I've got plenty of questions.
Yeah. Yolanda's waiting for us to get to that.
Well, I think there's another question.
Yeah, the second part of my question was, what does it cost to retain an attorney to file a patent application?
To file a provisional or a non-provisional?
Actually,
Just-
both.
Right. So I'm in the same school of thought as Eric, where ideally, if I'm going to file a provisional application, I want to put as much detail into it as I would a non-provisional. A provisional application doesn't have to include what are called claims, but you still want to be thinking in terms of the claims, which are basically like an element by element. My invention is A, B, C, D, E, and anybody who comes out with a widget that includes A, B, C, D, E infringes my widget, even if they also have F and G in there. But if they only have A, B, C, D, they leave out E, they don't infringe. That's essentially what claims are, and that a lot of thought goes into those. So you could save maybe a little bit on that. Having said that, I mean, a non-provisional application is usually in around the 10,000 mark plus or minus, depending on, you know, the complexity of your invention. Provisional application, maybe I've done them for the more of like the $5,000 range, but I wouldn't recommend trying to skimp too much on those, because eventually you're gonna have to, it's gonna catch up to you where you're gonna have to either walk away with nothing or invest more to get your protection.
Thank you.
And the 5,000 to 10,000, that's with having you fill it out. If you were to fill out for a non-provisional yourself,
Yeah.
what's the cost?
Oh, if you were yourself to file a non-provisional patent application? So you'd be on the hook for the U.S. Patent Office filing fees, and depending if you want to try to meet the drawing requirements yourself, you may or may not want to hire at least a patent draftsman or an illustrator to prepare the drawings, which might be like $100 a sheet or so, and then the filing fees. The basic filing fee for if you're a micro entity, like a typical individual, is 400, maybe 440 or so. If you were a small entity, like fewer than 500 employees, is 800, and large entity or undiscounted entity, they call it maybe around 1,600 for the basic filing fee.
If I could, I just want to, I'm sorry, I don't mean to interrupt, I just want to kind of add a different perspective. And these guys may not want to hear this, but when you put on your business hat,
I was just gonna ask
when
you.
you
How
put
many
on,
patents have you filed?
what's that?
How many patents do you file?
I've got 5 under me and my brother's got 25,
Right,
so.
so I want your perspective too.
Is I look at it from a business perspective, and being a young engineer, trust me, when you design something that's really cool and you're very passionate and protective like a little baby, but in the grand scheme of things, and you take a step back, what does it mean to the bottom line? You know, that's what you gotta take a look at. And it's hard to divorce yourself from the nurturer to the guy or gal trying to make money. You know, if you look at the front end exposure financially to do this. And I'm not saying patents are bad, I'm saying, but just have your head on straight when you look at it, is what's the bang for the buck? You're gonna spend the money, what's it gonna get you? Is it gonna defend you from somebody ripping off that product? Is it gonna be an offensive move to keep another guy out of the market? Or is it just to feel good? And when it's all done and said, since you wanna be in business, does it feed the bottom line? And if it doesn't feed the bottom line, you gotta take a step back, as hard as it is, say, I'm gonna go into production without a patent, or I'm gonna at least get a provisional, but I'm gonna go full steam ahead because this company can't live on one patented item. I'm gonna have longevity, gotta have that pump just churning them out. So think beyond this one, get it in production, make your money, get the next one, get the next one, get the next one. Because just one other thing, I won't bore you with the stories, but if you have a really neat product and it can make somebody a lot of money, there's somebody out there with deeper pockets than you, they'll bury you. So just keep that in mind, and I don't mean to rain on a parade, but that's kind of the business side of it.
Well, EIGERlab sits on both sides of that stool. You know, we understand that not everybody can afford a patent. Not everybody needs a patent. And many times we're suggesting they go as fast and as hard as they can to create brand awareness, so that they can separate themselves from the future competition. Brand, understanding that even if they could afford a patent, I'm not sure they can afford to defend the patent.
It's true.
So we take all that into account. On the other side of the equation, if you're gonna go for investor dollars, and you want a third party to a VC or an angel or somebody to invest in your idea, the value of your idea is significantly higher and more protected if you have a patent or some IP protection. So I think what I heard was, you walk down this path that says, the more independent research you can do on the patent, the better. The more that you can bring to an attorney, the better. That will save you some dollars. And then the next step would probably be file for a provisional. Typically,
Yeah. You may or may not start with that. I mean, it's not usually the path that I recommend to my clients, but if you're on a particularly tight budget and you're just speculating initially and you don't want to go all in, you can start that way.
okay.
Yeah, what I would say is if you're not sure whether this is going to be a go, right? You're not sure you're all in on this invention, then you either hire a patent attorney and you've done the search, so you could do a patent search. And if you say to yourself, oh, I'm not going to go ahead if I can't get a patent on this, then you're done after a patent search. But some people say, I want to go ahead with this product no matter what. So once you get to that step of filing an application, if you want to, the kind of lower cost way to do it is provisional, and then work really hard in the next 8 months so that you know, or 10 months, so you know whether it's worth to take that next step investment and going whole for the whole thing. I mean, I tell all my clients this, and unfortunately sometimes folks don't, and sometimes you can't get enough traction in that time. But really, you should push it as hard as you can, because that's a substantial investment. And if you got customers lined up or other positive feedback, then you know whether it's worth it to invest in the next stage in the patent process.
What happens if you sign a provisional, and at the end of the year, when it's up, you are on that fence of saying, I don't know if we should do it or shouldn't do it. What are the alternatives at that point?
Well, have you publicly disclosed it?
More than likely.
Well, then.
Well, I mean, if you have an NDA, it's not publicly
Right.
disclosed. So
Yeah,
I would say if you don't, if it's not been publicly disclosed, what are your options?
So if you haven't publicly disclosed it, if you let that expire, you don't have any 1 year bar. You don't have this clock running against you. So the only other thing you have is some unknown third party that might file something before you end up filing. Because if you go past the 1 year, you lose the benefit of that provisional filing date.
Is
So.
there anything preventing you from just filing another one to give you another year?
No, but they don't tack on, right? So you can't get back to the beginning.
You lose that first year, but you
Right.
could start over again.
You could start over and starting from the date that
Yeah.
you,
But
that
if
date.
somebody else filed
prior to you filing your,
Right.
if somebody else beat you by 5 days, you're gonna
So,
waste
so
your
you're
money
risking
because
that,
they
you're
just
risking
beat you out.
third-party filings, but maybe nobody filed. So, I mean, again, it's a cost-benefit analysis. Do I wanna bear risk, or do I wanna invest in the process?
Back on the public disclosure, if you gave a 3-minute pitch, a fast pitch, like we have on a product,
Yep.
does that constitute public disclosure?
I would think so, yeah.
I mean, you haven't necessarily described all of the details of how it's done, how it works. You just threw out an idea, and in three minutes, you're not gonna be able to explain everything.
Well,
So
I mean,
that's
you could
not
probably,
full public disclosure.
you could probably spend a lot of time litigating what was disclosed and what wasn't disclosed in such a situation. But it's, from my perspective, I don't wanna get into that. You're either gonna go the safe route or you're gonna take the risky route. Now maybe if you're past that point, you sit down with the attorney, you say, what was said there? What are the details? Is there something that wasn't disclosed? And you try to find out what I could do if I'm already past that point. But on the point of not being past that point, I would just say, get everything done ahead of the deadline.
Well,
Go ahead,
with the Chinese out there and Walmart and all these other, foreign manufacturers, I've read where the patent office just doesn't have the clout that it used to. The patents aren't as worth as much money as they used to. And, well, from what I've read, patents involve structure, trademarks involve packaging. So if your product or item has a unique form or look of packaging, and you have a lock on the raw materials for that packaging, then can't you protect your product from trademark infringement and just skip the whole patent route and get out the door with that? Because well, the Chinese they don't do plastic very well, and they don't do glue very well. It's from what I've learned. So, I mean, if you've got the raw materials right here at home, and it's got a unique look to it, and involves packaging, then skip the patent process. I mean, it's the Tabasco sauce. There's 100 kinds of hot sauces out there. There's only one Tabasco, and that's all there are.
Looks like Yolanda has.
Okay. Well, and I didn't know, maybe after I talk, someone would want to address that decision to forego patent protection in those circumstances. But yes, trademark or a trade dress can protect your packaging. It can also protect product configuration. So if you can show that there's secondary meaning that has been achieved right, in the marketplace, then you may also be able to protect the configuration of the product. But that's risky if you're going to solely rely on trademark protection. It is broad. Unlike a patent, you have potentially infinite protection, so you don't have to worry about 20 years as long as you continue to maintain the trademark through the proper filings. You would have the protection, but still competitors could come, so close and not actually knock it off, and it may not be infringement. So that's why I say it's risky, because you could have similar packaging, and unless you're willing to litigate it, then you may have a competitor who's using similar packaging and not infringing your trade dress. But you're right that you could try and use trademark as protection for the packaging if you're primarily concerned about the packaging and you think that it is going to serve as an indicator of source to the public instead of relying on patent protection for the underlying product.
So let's move towards trademarks and copyrights for a second.
Okay.
You still have a question on patents?
And this is a question on trademark. What are the costs and fees associated with filing a petition or application for a trademark?
Okay, so for a trademark application, the actual government filing fees, I think are around somewhere between $275 or $325 per class. So for trademark, you have classes for groups of or categories of goods and services. So for instance, if you have a product, you may want to file for the product, but if you're using it in connection with a service, then you may also file in a services category. Okay? You have to be careful with trademark because you want to make sure you're filing in the proper class. or classes. And so it would be upper 200s, lower 300s per class of goods or services.
And to retain an attorney to assist you with that would be approximately how much?
To retain an attorney, and some attorneys do flat fee pricing for it. You could do a trademark filing for probably a couple thousand, maybe a little less.
So I have another
Thank you.
any other questions on the cat before we move it through?
Oh, I think Jeff has
I
something
got
to
it.
add.
I mean, depending on how simple it is, you might be down around 1,000 for trademark filing. If it's, you know, and again, that would be where, if it's one class, you know, an hour or two of attorney time just to get your goods description down pat the way you want it to be.
I got a question about the search. What can you as an attorney do that I can't do on a search? If I go to uspto.gov and do a search and do all kinds of names and look, what can you do that I can't do myself?
For a patent search or a trademark search?
Patent.
Well, there's things that we can do that you can't do, and there's things that you can do that we can't do as well. Because I mean, you're the one who understands your invention the best. The patent attorneys, we know a lot of different ways to search. There's classifications, and there's you know, there's ways to search for related applications and things like that, nuances like that, and you know, we might take notice of some potential issues where you might be getting into hot water with another patent by looking at its claims and saying, hey, you know, maybe your invention distinguishes over this, but you know, we found this patent that you might want to know about because, you know, because a patent, even if you get a patent, it's important to note it doesn't give you the right to practice what you have patented. It only gives you the right to exclude others. So you could get a patent on something and go out and practice your invention and find out, oh, you're infringing someone else's patent that, you know, maybe disclosed and claimed a widget with ABCD. Your widget is ABCDE, so it's different from theirs. It's new, it's non-obvious, but when you practice your widget with ABCDE, it has ABCD in it, so you might find out that you know, you're infringing someone else's. And there's some nuances to obviousness analysis too that you know, an attorney might have a sense of different of when they get the search results, how to sort of pare them down and look at what might be some considerations that examiner might look at with this thing that's in maybe a related or some kind of adjacent field, and you know, how likely they would be to reject your invention as obvious over something that's close but not quite.
So experience is what you're saying.
So yeah, there's some experience, and it's partly in the searching and partly in the analysis of the results that the experience pays off. But you, I mean, especially at the beginning with the attorney, you're educating the attorney on what your invention is, and that's part of that is going to be coming to the attorney and saying, here's the closest stuff that's out there, and here's how my thing is different. So that's why I think it's very valuable to do your initial search before you come to an attorney.
Thank you.
The only thing I'd add to that, and I agree with everything you said, is if you do a search and you say there is nothing related to my invention, you have not searched well enough. In
Right.
every,
Yeah.
we get clients come all the time, there's nothing. I've never had a search where there wasn't anything relevant to the invention. So if you come back and say there's nothing related to my invention, then you need to keep searching, or you need to hire a searcher.
If I could add just a little bit more detail, when you are, like these fellows said, you're the most knowledgeable of what that thing is, what your design's supposed to do. So whether you do the search or you do it in collaboration with your patent attorney, the devil's in the detail. All the claims in the back that really put you to sleep are the things you really need to pay attention to. Because I know these guys will jump in and support it, but that's where you get your protection. It's all the ramifications and iterations of what it is you've designed and what it can do and how you're gonna make it and how it's gonna do whatever it is it has to do. But those claims are what's gonna protect you, not the first couple pages with pictures and all nice graphs. It's the back 4, 5, 10, 20 pages with claims. At least that's been my experience.
What's the risk if you do infringe? Say you've done your search and you decide, okay, well, I'm gonna apply for a patent and I'm gonna go to production on it. What are the risks involved at that point then?
Right, well, there I would say that, you know, how much have you invested into your idea? You know, have you tooled up for something? Is it something where, if you have to roll back your product release, how hard a hit is that gonna be? Because there is, it's expensive to hire a patent attorney to do an exhaustive, what we call freedom to operate or freedom to practice investigation. That can be as expensive or more expensive than filing a patent application, because there's no limit to, you know, how broad a range of patents you have to look at so what a lot of times people prefer is if they know of one patent that they think might be a problem, they might hire an attorney to say, okay, take a look at what I want my product to be and look at this patent and let me know if my product infringes or might infringe this, or how we might modify my product or service or whatever to get around it. But yes, I mean, usually it seems like those full-blown freedom to operate investigations are becoming less popular, and I don't know if that's your experience, but yeah, I mean, so the risk would be, you know, depending on how long you've been doing the thing, they can make you stop. You can be liable for royalties if you keep doing something when you know of the patent. You could be liable for triple damages for willful infringement if you refuse to stop when they ask you to. So there's definitely some risks there. You kind of have to weigh the value of a freedom to operate search against how much it's going to hit you or how hard it's going to hit you if you have to pull something that you've invested in.
Yeah, I agree that, and I think there's kind of two types of searches, the freedom to operate versus what I would call the novelty search. And when I mentioned searches before, I think maybe even when you did, you were focusing on novelty. Is this new? Because as was mentioned, the clearance search can be very expensive, upwards over $10,000. We've had searches before, because it's hard to prove that there's no patent out there in a particular area that you would have any problem with. Whereas it's much easier to determine, is there any patent that discloses this feature, right? Because to analyze a patent and determine whether you infringe, I have to read the patent, I have to read the claims, I have to read the file history, the negotiation. It's very in-depth, right? But to know whether a patent has some part of your invention, I may only need to look for a keyword. I may only need to look at a drawing to know this is a patent I need to look at further. But that's just not true for a clearance. So, you know, there are occasions where clearing your product makes sense, but in many cases, I find clients skip over that because of the cost, and they just kind of bear that risk. Yes, somebody could knock on my door and say we're infringing, we have to stop, but hopefully you'll be selling a lot, and you'll have some resources to address that at that time. I mean, it's risk versus the cost of insurance, I would call it, for that clearance.
Right.
So I also want to clarify that what we're talking about right now is patents and U.S. patents. And does the U.S. patent protect you from foreign countries?
No.
I can say with painful history, no. They do not, and particularly if it's very common. I know the trends, reshoring is a good term now, where business that was sent overseas is coming back, primarily China, because it was a lower cost labor. But if any of your companies or you're entertaining getting things done in China, and I'll say China, and it's of any volume, which means do you have a lot of annual volume, what's your EAVs, you're gonna be making a lot of these things, and they think it's a great idea to steal, they will steal it and put you out of business, and there's nothing you can do about it.
Right, as for them, you know, practicing the invention abroad, I mean, importations are infringements of US patents, so if you can catch them, somebody importing your product from China, that's covered. And then, you know, there's certain extraterritorial reach with, say you're, if you have like a patent that covers a method of making such and such, and if they make it abroad and import it here, there's a special statute that defines that as infringement, even though the claim isn't directed to the product. But you know, the general rule is no.
So I want to move the conversation sort of away from patents and more towards trademarks and copyrights and other forms of protection. Not everybody in here try. Some have web-based businesses, some create apps, some create software. So what are some of the tools available beyond just a patent or a patent to help protect in some form, limited or some of these products? And Yolanda, you want to take this and run with a little bit of definition of copyright and definition of trademark and then?
Sure. Well, copyright protects creative or artistic works, and there's a wide range of subject matter that falls under copyright protection. So it could be a literary work or choreography, a pantomime, musical work, sound recordings, architectural works, computer software. A wide range of subject matter falls under copyright protection. Unlike patent protection, you're not required to file an application in order to have protection. You have protection at the time you create it. But filing the application with the U.S. Copyright Office affords certain benefits. One of the main ones would be if you are going to sue someone for infringement. So if you're going to sue for infringement, then you would need to file. But under the law, you can file once you've discovered the infringement. You have a certain period of time to then file an application for registration. And the requirements aren't as rigorous as the requirements for patent. If you can show that it's fixed in a tangible medium of expression, so whether if it's software, if it's been fixed, or if you're writing a book and it's been fixed in that medium, then that's one of the requirements. And then you must also show that it's original, but not novel. So it doesn't need to be new. You just have to establish that it's original, which means that it's independently authored, that you didn't copy it from a third party, and that there's a minimum level of creativity. And the courts have interpreted the originality threshold to be pretty low. And so those are the two primary requirements for copyright. And the cost of filing an application is $35. So it's very inexpensive if it's a single authored work. Then the cost is $35. It goes up from there if it's a work made for hire, or if you have joint authors, then it goes up. But certainly compared to trademark or patent applications, it's quite inexpensive.
When would I use a trademark?
A trademark application. So trademark protects words, names, symbols, and devices. So if you're using your word, name, a logo in connection with a good or service, and you want to file a trademark application because you want that federal protection. But again, you don't need to file an application for federal protection. It affords certain benefits, but if you're using it, then you're already afforded common law rights. So you would have rights before you filed for the federal application. Yes.
What is the difference between just having a trademark and a registered trademark? Registered trademark is when I file the application.
Right. So registered trademark is when you file the application with the U.S. Patent and Trademark Office. And you can file based on use. So if you're actually already using it, and you would attach a specimen of use to your application. or you can file an intent to use application. And you're signing a declaration that you do intend to use the mark at some point. And if you're not using it after 6 months, you can get an extension up to 36 months. And then at that point, you do have to show a specimen of use.
How long does that last? That-
Trademark?
The registered trademark?
Potentially, it's perpetual or for an infinite period of time, as long as you file the requisite documents, the requisite filings.
And do you have to keep using it?
You do have to keep using it. Okay, if you haven't used it for 3 years, that's prima facie evidence of abandonment. So you do have to keep using it.
If I have this registered trademark already, and I know that someone is it considered infringement if someone else is using this name?
Yes. If someone else is using it, and the standard for infringement for trademark is a likelihood of confusion. So you would argue that there's a likelihood of confusion between that mark and your mark.
Okay. What are my options in that particular stance? What can I do to this person?
Well,
write them a letter?
First, you could try to send a cease and desist letter, which is sometimes successful. And in the letter, you would identify yourself as the holder of this federally registered mark, and you would demand that the third party cease use of the mark, of their mark.
Okay. It does not protect a product, correct? I mean, it's the
That's
name
correct.
of the product.
It's the name or word or logo used in connection with the good or service. That's correct.
Unless you mentioned product configuration.
Oh, unless it's trade dress, okay, and then that protects the configuration of the product. But in order to have protection for product configuration, you have to already establish secondary meaning. Okay, so that is a requirement for product configuration.
Okay.
Unlike with other trademarks, if you file it, you don't have to establish secondary meaning. You may have not even used it yet, but for product configuration, in order to have that protection.
So that I understand exactly what you're saying, I'm going to repeat this. When you said that it has to establish secondary meaning, so in other words, my name of my product is basically the description of my product, okay? And how my product is made, and that's what we call this particular product. Is that what you're talking about?
Now, secondary meaning is association of your product with you as the source of it among the public.
Okay.
But you said that it describes your product. So if you haven't filed, okay, and you file a trademark application, you can get a rejection or an office action based on descriptiveness. If your word describes the good or service, that is a pretty common rejection. Likelihood of confusion is another. If you file and there's already a federally registered mark or a pending application for the same mark, and the examiner thinks that it's similar, then you could get a rejection on that basis as well, which is a risk I think you run when you file it yourself. And I know with firms, and our firm does some flat fee billing, that they'll include office actions. So not just filing the application, but you may receive an office action from the PTO, and it may be rejected. It could be something simple like you need to disclaim one of the terms in the mark, or it could be something more complicated like a likelihood of confusion, rejection, or a descriptiveness refusal.
Okay, one more thing and then I'm done. With the trademark, I have two trademarks, any registered trademarks.
Okay.
So you get 8 million letters from all these companies all over the world that say, we're gonna protect your trademark. And I was told by the, I didn't, but I was told by the trademark company, by the United States trademark, throw them in the garbage, so
Right.
I just wanted
I
to
think
say
they
that.
have something on their website now that particularly addresses those type of communications.
Yeah, they troll the website, and it could be like days after you file electronically, you start to get emails from everybody saying, oh, we're gonna help you with your trademark.
So if I have,
Thank you.
if I want a trademark, I have water. Nobody said that they have water. per se? I mean, what is it that, where do you actually get the trademark?
You're saying that the phrase, "I have water"?
Well, just water.
Or
All right,
just-
my trademark is water. Nobody's taken it yet.
What's the product?
Water.
It's generic.
But, okay, I have bluegrass. Okay, if I had something, where do you come in with how do you determine when you want to copyright something that's not being so vague, I guess? It just, some of it seems kind of silly to me.
But there's like a spectrum that you could talk about,
Right.
ranging from
Right,
generic
so there's a spectrum of distinctiveness. In order to have a protectable trademark, it must be distinctive. Okay, generic marks do not qualify for protection. So if your mark is water and you're using it in connection with water, that is the common name for that good. So that's not protectable. But then there are a range of marks that are protectable. Descriptiveness would be the lowest level of protection. So if your mark describes your product, then you would have to establish secondary meaning, because descriptive marks are not protectable unless you can establish secondary meaning that the public actually recognizes it as a trademark, as an indicator of source, and not merely as a description of your product. Then the next level would be suggestive. If your mark suggests some of the qualities or attributes of your product or service. So it doesn't directly describe it, but it does suggest some of the attributes. You don't have to show secondary meaning for a suggestive mark. And then the highest level would be a fanciful or arbitrary mark. Fanciful marks are marks that are coined. They're created for the purpose of serving as trademarks. So Exxon or Pepsi, those words had no meaning until they were created by those companies to serve as trademarks. That's the highest level of protection, and you also don't have to show secondary meaning. And then fanciful marks, they have a dictionary meaning, but their use isn't related to the product or service. So Apple for computers, for instance, that's a trademark, but that mark is in no way related to the product or services. So there are different categories, but your description, that's generic, and you wouldn't be able to protect it. And trademarks are quite valuable to companies, especially once you've achieved that secondary meaning and consumers are buying your product because they recognize the mark and they associate it with a certain quality. And we often buy products only because we associate them with a certain quality. So a BMW really may not run differently than a Cadillac, but it's a BMW, so more people buy it because it's a BMW. So you're not protecting. I mean, I'm using, that might not be a good example. Maybe BMWs don't. Some people might say BMWs do run better, but you can think of examples maybe of other products where you buy it for Nike, and maybe Nike tennis shoes aren't any better than New Balance, but it's Nike, and more people buy Nike because they recognize it as quality.
I have a question. How do you establish secondary meaning of something that's initially gets rejected as descriptive?
Oh, you do have to provide evidence. So you would have to provide evidence to the examiner. Advertising, sales, that type of evidence to show that you have achieved that secondary meaning.
Isn't there like a 5-year period?
Right, you're right, and there is a 5-year period.
So
Yeah.
you get a presumption.
After 5 years, you have a presumption of the secondary meaning if you provide the evidence and you've been selling it or have the advertising and it's for a 5-year period. Yeah.
Larry?
Yes, thank you. For our particular purpose, our company works with a product that we do not own. And they have their own product name, their own patent for the product. But they really do not have a very good marketing program, and we believe we do, and that's what we intend to push. And part of the development of that marketing is in the servicing of the product, in its use. And we come up with a new name for the servicing. We call it a certain name. The company never had that name. They never used that, any of that. We came up with our own company name as Cleaner Air Technology, we use the acronym CAT. And with the CAT, we come up with a black cat. And a lot of our associates are worried that a Jaguar is going to be knocking on our door. So with a product that is environmentally, that cleans the environment, has great benefits to fuel economy, nothing to do with a car, could our cat pass for hours, and could our words be copyrighted or trademarked to a product that we don't own?
Okay, so I'll begin with your first question. Jaguar may make the argument, right, that there is some likelihood of confusion if your service relates to air and cars produce pollution. I think